Caveat. The term caveat has not been defined in the code. The word caveat has been derived from Latin, which means beware. According to the dictionary meaning, a caveat is an entry made in the books of officers of a registry or a court to prevent a certain step being taken without previous notice to the person entering the caveat. In other words, a caveat is a caution or a warning given by a party to the court not to take any action or grant any relief to the applicant without notice or intimation being given to the party lodging the caveat and interested in appearing and objecting to such relief. It is very common in testamentary proceedings. It is a precautionary measure taken against the grant of probate or letters of administration, as the case may be, by the person lodging the caveat. The person filing or lodging the caveat is called caveator. Section 148A of the Code of Civil Procedure provides for a lodging of a caveat. Section 148A. Section 148A, as inserted by the Amendment Act 1976, is a salutary provision. It allows a person to lodge a caveat in a suit or a proceeding instituted or about to be instituted against him. It reads as under: where an application is expected to be made or has been made in a suit or a proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on hearing of such application may lodge a caveat in respect thereof. Where a caveat has been lodged under subsection 1, the person by whom the caveat has been lodged, hereinafter referred to as the caveator, shall serve a notice of the caveat by registered post, acknowledgement due on the person by whom the application has been or is expected to be made under subsection 1, where after a caveat has been lodged under subsection 1, any application is filed in any suit or proceeding, the court shall serve a notice of the application on the caveator. Where a notice of any caveat has been served on the applicant, he shall forthwith furnish the caveator at the caveator's expense with a copy of the application made by him and also with copies of any paper or document which has been or may be filed by him in support of the application. Where a caveat has been lodged under subsection 1, such caveat shall not remain in force after expiry of 90 days from the date on which it was lodged, unless application referred to in subsection 1 has been made before the expiry of the said period. Object. The underlying object of a caveat is twofold. Firstly, to safeguard the interest of a person against an order that may be passed on an application filed by a party in a suit or a proceeding instituted or about to be instituted. Such a person lodging a caveat may not be a necessary party to such an application, but he may be affected by an order that may be passed on such application. This section affords an opportunity to such party being heard before an ex parte order is made. Secondly, it seeks to avoid multiplicity of proceedings. In the absence of such provision, a person who is not a party to such an application and is adversely affected by the order has to take appropriate legal proceedings to get rid of such order. Such a provision is found in the Supreme Court Rule 4. The Law Commission therefore recommended insertion of such a provision in the Code of Civil Procedure also. Accordingly, 148A has been inserted by the Amendment Act of 1976. Nature and scope. Section 148A enacts that a caveat can be lodged in a suit or a proceeding. Considering the connotation in a narrow manner, some high courts have taken the view that no caveat can be filed in a first or a second appeal or in execution proceedings. But, as observed in Ramchandra Agarwal v. State of UP, the expression civil proceeding in section 141 of the Code includes all proceedings which are not original proceedings. Thus, the provision relating to caveat would be applicable to suits, appeals, as well as other proceedings under Code or under other enactments. Again, it is no doubt true that no order should be passed against a caveator unless he is heard. But if the caveator is not present at the time of hearing of the application and the court finds that there is a prima facie case in favor of the applicant, ad interim relief can be granted by the court in his favor. Interim orders passed without giving notice to the caveator is not without jurisdiction and is operative till it is set aside in the appropriate proceedings. Who may lodge a caveat? Subsection 1, 148A prescribes qualifications for the person who intends to lodge a caveat. He must be a person claiming a right to appear before the court on hearing of the application, which the applicant might move for grant of interim relief. The language of subsection 1 of section 148A is wide enough to include not only a necessary party, but even a proper party. Hence, a caveat may be filed by any person who is going to be affected by an interim order likely to be passed on an application which is expected to be made in a suit or proceeding instituted on this behalf. ఏమైంది మళ్ళా?